This isn't a simple divorce. It's a full-blown battle. The couple is fighting over money, cars, loans, and even guns. Each side insists the other is breaking court orders. Accusations fly about missed payments and ignored responsibilities. The judge steps in, ready to cut through the excuses. But patience is wearing thin. By the end of this hearing, clear deadlines will be set. And missing those deadlines won't just mean trouble. It could mean contempt, fines, or worse.
Okay, counsel, I apologize for the delay there. I had another matter that went a little bit longer than I anticipated, so we are a few minutes behind, but I do want to go on the record now in Sarah versus Sarah. This is file number 2311355.
The judge wastes no time, making two big issues clear. First, claims of unpaid obligations, and second, objections to the divorce judgment. In family court, the written order is the referee. It decides what counts, not emotions or excuses. The key question is simple. Has each side followed the rules, or are they hiding behind technicalities? If the judge finds willful disobedience, the result won't be more warnings. It could open the door to contempt of court.
If I can have both counsel put your appearances on, starting with plaintiff.
Alan Byrne on behalf of Mrs. Sarah, who's present, seated to my right.
And Michael Cutler on behalf of Stephen Sarah, who is on screen.
Okay, we're set for two matters in this case today. Number one, the first thing I'd like to address is plaintiff's motion regarding alleged failure of defendant to comply with the court's ruling. And then we have Mr. Cutler, defendant's objection to the proposed judgment of divorce drafted by Mr. Vernon. So Mr. Vernon, addressing your client's issue first, my understanding based on the written submissions is that your client's motion is based on the failure of Mr. Sarah to make payments.
Yes, I did not participate in the drafting of that document. Mrs. Sarah did that of her own accord.
The plaintiff lays out a list of missed payments: car notes, insurance, pension contributions. None of these are minor. They're central financial obligations. A single missed payment might look like a mistake, but when several stack up, it forms a pattern. And in the eyes of the court, a pattern of non-payment isn't an accident. It signals deliberate disregard for the court's order. That difference can shift the case from late bills into legal penalties.
My understanding is that Mr. Sarah has failed to make payments on the vehicle. The March payment has not been made. The April payment is due. That has not yet been made. And the, was it the car?
Support, the insurance.
Oh, and then and then there's the support that hasn't been paid.
And the pension.
Right. When I say the support, I mean, I suppose I mean the pension as well. But so none of those payments have been made. In court order states fairly clearly that Mr. Sarah was intended to make those whether this order was entered or not, or at least until it was entered. And because counsel objected, we have not yet had an order entered until probably today. Mr. Sarah would be responsible for making those payments.
All right, thank you, Mr. Cutler.
Thank you, Your Honor. As far as the pension, that topic first, the pension is not paid for my gentleman. It is through the pension agency. The pension payment was requested and it was submitted. Our understanding, confirmation from Mr. Sarah, is that the 1/2 portion of the pension was paid on March 29th. They do it automatically every month. As far as the payment,
the defense strikes back. They argue their client isn't the one at fault. Instead, they blame the plaintiff for not transferring the car title and loan like the judgment required. This kind of standoff is common in divorce cases. Each side claims they can't act until the other does. But judges dislike this stalemate defense. It drags cases into endless loops of blame. And while both sides point fingers, the judge is left with a case that goes nowhere.
Of the $1,000, we did not have any address for Ms. Sarah. I contacted opposing counsel. Eventually, I got a response from him within 4 days of getting that response. my client submitted a cashier's payment in the amount of $1,000 to the P.O. box that was provided to us. As far as the car and the insurance, the order of the court, the opinion of the order of the court was that both parties were to engage in certain activities relating to the vehicle. Ms. Sarah was to transfer the title and transfer the obligation to her name. Apparently, she has not undertaken any steps in that regard.
Okay. All right. So the court is going to order that the pension payments. Well, first of all, can we, Mr. Vernon, can we put on the record here today an address for Ms. Sarah that the payments should be sent to?
It's P.O. Box 147, Grayling, Michigan, 49738.
I'm sorry, can we have that lower? I was writing it down, Your Honor.
P.O. Box 147, Grayling, Michigan, 49738.
Thank you.
Okay, so the court's going to order that the March and April payments.
Here comes the first major ruling. The judge orders specific payments, pension and vehicle, to be made within 14 days. These deadlines are more than reminders. They are enforceable orders. Miss the date and the non-paying party risks contempt. Contempt means fines, wage garnishment, or even jail. The message is clear. Follow the timeline or face serious consequences. It's the judge's way of giving one final chance to comply voluntarily.
As provided in the court's opinion, in order be made within the next 14 days and sent to that address. With regard to the vehicle, those obligations, in my view, would not arise, unlike the payment of the pension and support, which the court expressly provided for in the opinion and order. The other provisions, such as the vehicle, would be effective at the time that the judgment of divorce is entered. So I don't find that Miss Sarah's obligation has arisen until that judgment has been entered, which I suspect we're going to be able to resolve here as the next matter today. So I am going to order that Mr. Sarah make the March payment as to that vehicle, as he has been making all along. And then that, assuming we address the issue with the judgment of divorce, then once that's entered, then that obligation will transfer to Ms. Sarah, along with the obligation to refinance that vehicle and remove Mr. Sarah's name from it. So that's how we'll handle those two issues. With regard to moving on to the next subject of the motion, which is Mr. Cutler, your motion regarding the judgment of divorce, I did review your filing. Is there anything that you wanted to state in that regard today?
No, Your Honor. I think I highlighted, I requested drafts of the judgment so we didn't have to have this delay. Unfortunately, I never received the draft. I never received what I had hoped to be cooperation to review the language to address these. I think I have 3.
The next battle is over wording. To outsiders, grammar and phrasing may seem minor, but in divorce law, one sentence can shift thousands of dollars of responsibility. Defense counsel insists on tightening the language now. Why? Because any vague wording can be used against their client later. It's not just about commas and typos. It's about preventing loopholes. Small changes today can protect a client from massive problems tomorrow.
Requested actually 2 changes, 1 omission, and then 2 grammatical errors, which include provision that I don't think the court ordered. So it's really 5 issues in total. Unfortunately, we're delayed to today's date, but I do want to have those addressed. And I think I expressed them to the court unless the court had any specific question of me.
I don't. Thank you. Mr. Vernon?
So I'll take them one at a time. With regards to the language that Mr. Cutler proposed for the vehicle that states that Plaintiff will be required to remove the defendant's name from the title and debt. I think that's consistent with the court's instructions, so I have no objection to that language. The student loan, we did refer to it as the Parents Plus, and the court did refer to it as student loans. I have no objection to that. There is a request in the in Mr. Cutler's answer to the show cause, suggesting that my client is responsible for one half of the monthly payments. I would disagree with that, and that the language in the order that the court drafted simply said that the debt is divided equally, not the monthly payment structure is divided equally. So I think that is an inappropriate language. So the proposed language that is in there with regard to the student loan, that states that the student loan debt, including any Parents Plus loans made by the parties during the marriage, is to be divided equally between the parties. I don't have any objection to that language. With regards to the attorney's fees, again, that's fine. I don't have any problem with that language being added. I think the typos that he pointed out are accurate, should be corrected. The only other thing I would add is that the Michigan Court Rule 2.602 subsection B3C identifies that the party filing the objection, that would be Mr. Cutler, must serve on the parties all of the objections together with a notice of hearing in an alternative proposed judgment or order. Mr. Cutler did not do that. He included the proposed language in his motion, but we do not have a proposed alternate order. So the suggestion that I have to make those changes to the order, I believe, is inconsistently placed, consistent with the court rule, and that is something that Mr. Cutler would have to draft and submit.
May I address that, Your Honor?
Yes.
Thank you. Once again, if counsel responded to my request, and I sent 3 or 4 requests for the draft, then I could have obviously included some of these changes. For whatever reason, I received no cooperation, and I've adhered to the court's opinion stating that objections would need to be filed as opposed to an objection with a separate motion was pursuant to the court's order. Counsel has the language. The changes are minor, so I'd ask that he make those changes in light of the history of our relationship up to this point. I would like to make one inquiry of the court. The court specifically stated that the student loan debts, these Parent Plus debts and obligations, are marital obligations. They are to essentially be equally shared between the parties. If Ms. Sarah is not going to be submitting any of the payments, if she's going to refuse to submit her half portion of it, my client does not earn sufficient funds. The court has the numbers clearly. My client cannot make that payment. I would ask alternatively that if
The defense makes an emotional appeal. They say their client simply doesn't earn enough to cover both halves of the student loans. If forced to pay, he won't even have money for food. It's a risky strategy. Courts don't usually rewrite judgments just because paying them is hard. Orders are meant to be followed. But if the judge believes there's genuine inability to pay, enforcement could be adjusted. Still, judges rarely accept "I can't afford it" as a long-term excuse.
Ms. Sarah does not make the required payment on this obligation, and the amount is, I believe, I know Mr. Sarah gave me some paperwork on it. I think it was $1,400. If he has to make the $700 payment for his portion and the $700 for Ms. Sarah's portion, he will not have enough money to buy food. So as an alternative to this, I would ask that if she's not going to submit the payment, that Mr. Sarah be given the option to submit the $700 from the spouse support obligation on her behalf. He can submit the payment to those loan agencies in a timely manner, and they won't be in default. Otherwise, we're going to be right back here before the court. So I'm trying to get ahead of a problem that, based on what counsel just stated, I foresee.
Okay. All right. First of all, with regard to defendant's objections, based on Mr. Vernon's statements, and I agree with Mr. Vernon and Mr. Cutler, looking at, first of all, paragraph number 1 regarding the vehicle, I think we all agree that, Mr. Cutler, your language is appropriate as cited under paragraph number 1 of your objection. With regard to the student loans, again, the court would adopt the language that you have proposed under paragraph number 2 of your objection. With regard to the attorney fees, again, the court would adopt the language proposed by Mr. Cutler under paragraph 3. And the typographical errors addressed by Mr. Cutler under paragraph 4. Neither of you referenced the cash surrender issue under the statutory insurance provision of the proposed judgment. Mr. Cutler, you raised that as an issue under paragraph 4 as well. I'm not sure what significance the difference is. To me, reading Mr. Vernon's paragraph, it looks like each side gets their insurance at any value that it might have. So is there a reason why you didn't want that language in there, or you didn't think it was appropriate?
I didn't believe that the court referenced in its ruling any portion to a cash surrender value. I believe it merely stated that each party essentially retains it. When we start getting into cash surrender values, then I start to be concerned as to what are the values and if they're offsetting. I'm just trying to reflect within the final judgment the language of the court.
All right, and I didn't address that. The parties never raised that as an issue for decision by the court or a dispute between the two of them. I don't view that as to be an issue that has particular significance here. So I'm not going to require Mr. Vernon to change the language of the statutory insurance provision in his proposed judgment. I do agree with Mr. Cutler that really from the standpoint of the resources of both parties, these changes will take minimal time and certainly much less time for Mr. Vernon to simply make corrections to the judgment that's already been drafted, as opposed to the time and expense it costs for the defendant to draft up an entirely new judgment. So the court will order Mr. Vernon that you make those changes to the proposed judgment and submit that to the court for signing. In terms of, Mr. Cutler, your issue regarding the student loan debt, I appreciate your efforts in trying to get ahead of that issue. Generally, courts are loath to decide any issues that aren't directly before them. Your motion involved objections to the proposed judgment. The court did not, as Mr. Vernon indicated, order as part of the opinion in an order that Miss Sarah make payments. And I can foresee that may be an issue that comes forward, but I view your motion much more, your request, Mr. Cutler, as a motion to enforce a judgment of divorce, the provisions of that hasn't been entered yet. So I think while I do appreciate your forethought in addressing an issue that may and perhaps even likely will arise.
The judge listens but shuts it down. The request about redirecting payments is called premature. Courts don't want to deal with what-ifs. They rule on the motion in front of them, not side issues raised along the way. This shows how strict judges can be about procedure. Even if a problem looks obvious, if it isn't formally on the table, it won't be decided. The defense must wait until the proper motion is filed.
At this point, I think it's premature, so the court is not making any rulings with regard to that request at this time.
Understood.
That is the ruling of the court as to both motions. That's all I have on this file today, and all parties are free to disconnect at this time.
Your Honor, if I could just ask, when is Mr. Vernon to submit that change? Can we have a time period, whatever number of days, please?
I would suspect, Mr. Vernon, can you have that within the next 7 to 14 days to the court?
Yes.
Okay.
Thank you.
Your Honor,
Your Honor, Mrs. Sarah, has a couple of questions related to the show cause order that she filed, or request that she had filed, so I'm gonna request the court allow her to ask a couple of follow-up questions.
Your Honor,
Okay.
to that, if we could, arguments that have been made, the court's already made a ruling.
It's just for clarification.
Yeah, I'm not changing it. Mr. Cutler, I assure you, I'm not changing anything about, but Ms. Sarah has questions. I'm certainly going to allow her to ask them. So go ahead.
So the March and April car payment, as well as the insurance, will be paid by the defendant, correct?
March.
March. Okay,
Yeah.
April due in like 3 days. Am I gonna have payment to pay it?
Yes.
Okay. The pension, I have not received anything. I should have received 2 months already. He gets paid on the first of every month.
Yeah.
And
Yeah. I've ordered that he make both months' payments within the next 14 days to the address that you provided.
Okay, Your Honor, is there any way that the payments can be made through the court so I don't have to deal with this for the rest of my life?
The defense proposes a drastic step: park the car. Since the title is still in their client's name, they don't want the plaintiff driving it. If an accident happens, the registered owner could be liable. Parking the car freezes the risk until refinancing is complete. It's a smart risk control move, but it also leaves the plaintiff without transportation. In divorce disputes, these tactical requests often become leverage for negotiations.
That's something that you can address through Mr. Vernon, but that's not something I can address here today.
And Your Honor, it appears that my client has some response. If likewise, he can be given the opportunity for clarification.
Yeah, if you have questions, Mr. Sarah, that's fine. I'm not going to get into a debate about when you get paid and when you don't get paid. So if you have questions, you can ask a question.
I can't hear you, Mr. Sarah. You're on mute.
I'm sorry, I do, Your Honor. I received a half payment on my pension as of, I received my pension towards the end of the month. And last month it was the 28th or 29th. And I did receive a half pension payment of roughly $925. I myself applied for the Quadra and made many phone calls to make sure the Quadra was in place. So as far as I'm concerned, the Quadra is in place. I do not know why I would get half a pension payment and Mrs. Sarah does not. Ms. Sarah, the plaintiff did not. The other thing I might request is I roughly make $4,000 a month. Paying the plaintiff half of that leaves me $2,000 with a over a $1,400 student loan payment, a $660 tax payment, which is marital taxes from 2021. That there is my entire income. I have no more money for another car payment or an insurance payment. I need direction on, out of my $2,000, which forget about rent, mortgage, food, utilities, what am I supposed to pay when I only get $2,000 a month? I'd like some direction on what I'm supposed to pay, please.
Mr. Sarah, my job as a judge in this case is to equally divide up marital assets and debts. I've done my best to do that. I didn't live your life for you. I didn't accumulate the debts that you've accumulated. I didn't put you in the position that you're in. So in terms of, I don't have any advice for you about how to live your life and do what you need to do. All I can do is do what I'm required to do, which is to divide up assets and debts as equally as I possibly can. And I've done that. To the extent you disagree with the way I've done that, your remedy is to appeal it. And I encourage you to do that to the extent that you want to get things changed. Otherwise, again, It's not my job to figure out how you're going to live your life. You need to figure that out on your own.
But I'm in an impossible position.
And I guess you put yourself in that impossible position by doing things the way that you've done. And that's not my fault.
Not maritally?
So I'm
All
not
right.
going to debate you. That's all I
Okay.
have to say. All
Thank
parties
you.
are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Also, complaints in this case. Ms. Sarah, what is it that you would like to say on your behalf here today?
Well, I still have not received any pension. Is now 5 months owed. I did receive an email from the pension company saying he finally completed the paperwork in June, which it was supposed to start in March. So I don't know where that's going. As far as his firearms, I have never had them in my possession. My son has them, and my son told me that he had talked with his father, and his father agreed that my son would hold on to them until they figured out what to do. I've never had them in my possession. So I know he keeps saying I do, but I don't know anything about guns. Why would I want them? A few were sold by my son just after I was forced out of my home. They made the car payment for a few months because I had no income, and they paid for my son's storage in California while he moved here. Also, he claims that I am late on the car payment. Well, he was supposed to pay the March and April car payment and insurance, and he never did. He still has not. I got a letter saying that, or an email saying that the car insurance is still in effect. Well, of course it is. I had to pay it, but he was supposed to pay March and April. I went without car insurance for 5 days, didn't drive the car because I had no money to pay it until I got support from him. At this time, it's over $5,000 when you count the pension, the car payments, the insurance. I don't know what to do from here. I'm at a loss.
Okay, thank you. Mr. Cutler?
Thank you, Your Honor. Couple things. First of all, I want to correct the plaintiff in this. The judgment was entered May 13th. The judgment was required in order to process the quadro. That had to be submitted because it's an order of the court. That was done, so it hasn't been 5 months. It's now in the third month, I guess, because it was on the 13th, short of the third month. My client has jumped through all the hoops. He submitted the final documentation. He'd be happy to acknowledge that under oath. So that is done by third parties, not by my client. He submitted everything he needed to submit. As far as the current status of the situation, our greatest concern, as highlighted in our motion and our answer, is that there's a car. The car is being driven. It was awarded to the plaintiff. It is being driven by her. If she runs over, God forbid, some person gets into a car accident, gets a ticket, it falls on my client. He is liable for it. No matter what she says, he's going to be held liable because he's still down as the owner of the vehicle. We believe it's appropriate that until such time, if she is ever to get a car loan and ever to take the title out of his name, that the car be parked and that it remain there. So we're suggesting the car be transported to my client's property, what he was awarded during the divorce. It will remain there, will not be driven. And nothing will happen with that vehicle, thereby alleviating the possibility of other lawsuits and other traumatic situations. We believe that's appropriate in the interim until something may or may not happen. In her answer, she indicates she went to Secretary of State and there's a lien. Well, of course there's a lien because there's a car loan on it and she can't transfer it. I don't know if she's ever going to be approved for it. So that's the initial, I think, most urgent request at this point. As far as the remaining funds, she has not paid half the money for the student loans like she was ordered. We believe that it's appropriate in order to prevent default and other further problems for the two of them, that the amount of, I believe it's $714, I put it in my motion, be credited to my client, that he can reduce that from his support obligations that he has been making, and he has done so every month. He made every payment. He's going to be fulfilling his July payment, but that amount be reduced by that $700 figure. He will pay it on their behalf, avoiding a default, and thereby alleviating further problems for the two of them until such time when maybe situation will change. As far as the rifles go, the firearms, the order of this court was very clear. If they are not returned to my client, he is to get credit for them. We added up exactly the amount for the attachment that was provided at the time of trial and as part of the decision of this court. The amount is $6,131.35. We've attached in response to her motion text messages where the the plaintiff is gloating. She forged my client's signature on these firearms, on the registration, that these firearms were all sold. Doesn't matter what the purpose is. That's all water under the bridge during the trial. Since they cannot be returned and she cannot apparently pay the amount of money, we believe it's appropriate he should have credit of that amount for the spousal support. So he's not creating more problems for himself. They're never going to be returned to him. He never had an agreement with anyone in the world. The decision of this court is very clear. She's supposed to return them. She's supposed to pay for them. She can't return them. Since she doesn't have the money to pay for them, we believe a credit is appropriate for that item. As far as the remaining aspects, when we filed our motion or after we filed the motion, it appears that the plaintiff did make a couple payments on the obligation for the Highlander, avoiding a default. So I'm glad she did that for the prior months, but she has not completed the other tests. My client, on the other hand, has continued the the car insurance. It's paid through October 11th of this year because it was previously paid under a policy. It's a 6-month policy or a year policy as they typically are. So there isn't any continuing payment that needs to be made as far as the car insurance goes. But that's only short term, and that's going to be concluding pretty soon. So of those issues,
The judge issues a strong warning. The time for excuses is almost over. Both sides must comply with the court's orders, or they will face contempt proceedings. Contempt is serious. It can mean fines, wage garnishment, or even jail until compliance is forced. It's the court's way of saying, do it now, or I'll make you. Family law rarely reaches this stage, but the judge makes it clear that the option is on the table.
we believe it's appropriate in the interim at this point in time, because we're not getting cooperation from the plaintiff, that he receive those credits, the credit for the firearm, the credit for the payment that he's going to need to make for student loans, and that the vehicle be parked and remain parked and not to be touched by either party until further order of the court, which may or may not ever happen. I'm not sure if the court had any questions of myself.
I don't. Okay. So again, I've reviewed what each party's allegations are. First, I guess I want to say, and Mr. Cutler probably already knows this as an attorney, but for Mr. and Ms. Sarah, everybody needs to understand the way that I'm viewing this. The court has an interest in and an obligation to enforce its orders. And so the court's determination is limited to whether or not either or both parties are complying with the court's orders. And if they're not complying with the court's orders, whether they have a legally recognizable excuse for not doing so. And if they don't, then what punishment or what can the court do to compel compliance? What it's not the court's responsibility or duty to do is to figure out for the parties how they're going to comply with the orders of the court. Mr. and Ms. Sarah came to this court. They asked for a forum to resolve their divorce. The court did that according to the law and rendered a decision that in the court's view was as equitable as it could be under all the circumstances. As far as I know, neither party has appealed that decision. So now both parties are stuck with what the court has ordered, and both parties are required to comply with those orders on their own. And again, it's not the court's role or duty or obligation to figure out for the parties or answer their questions or come up with strategies or solutions for them as to how they're going to comply. That is outside the scope of the court's responsibility in this case. And we're not dealing with any legal issues here. We're simply dealing with compliance with orders of the court through the court's opinion and through the judgment of divorce that was entered. As we sit here today, just based on the statements of the parties, I don't think either party has complied with the judgment of divorce. The court's opinion clearly states that Mr. Serra is required to give or provide half of his pension to Ms. Serra, regardless of whether a quadro has been entered or not, beginning on March 1st. And Mr. Cutler has not, as far as I can tell, has not alleged that Mr. Serra has done that. The point that was made here is that he's going through the process of getting a quadro, but he's receiving that money every month. There's no reason why he can't remit to her half of that money. And in any case, regardless, it was the order of the court that he do that beginning on March 1st, and he hasn't done that, regardless of whether a quadro has been entered.
And I apologize, Your Honor. I don't want to interrupt the court, but he is not receiving his full pension. He's only receiving half. Apparently, Ms. Serra needs to process some papers. So since the order of the court, he has only received half the pension. He'd be happy to acknowledge that on the record. The other half is waiting for Ms. Serra to fill out whatever form she has to fill out. I'm sorry I overlooked that portion. I'm sorry there's some confusion. I apologize for the interruption, but I want to make it clear. He has only received, since the entry of the opinion of this court, half of his pension.
Okay, well, I don't know whether that's accurate or not. I mean, Mr. Cutler, I accept your representation as what your understanding of it is. I don't know. I don't have any records in front of me that show that. All I know is what the court ordered. And I don't believe that those funds have been received. Mr. Serra was required to pay the car payment until the judgment of divorce was entered, which was in May. Apparently, he did not make those 2 car payments. Ms. Serra, pardon me, I'm sorry, I have a cold. Ms. Serra was required under the judgment to either return the weapons to Mr. Serra or provide him the value that was obtained for those weapons. I found, as a matter of fact, that regardless of whether it was the son that did it or Ms. Serra or a combination of both of them, somebody disposed of Mr. Serra's weapons, and he's entitled to those weapons. And so, Ms. Serra, you've got an obligation either through yourself or through your son to return those funds to Mr. Serra or return the weapons to Mr. Serra. In terms of the student loan debt, again, the parties are required to each pay half of that. It's not my job to decide how each of you are going to meet your obligation. I've simply determined that as a matter of equity, each of you should be required to pay that. And what I'm not going to do, because I can foresee this as being an issue, and I appreciate your suggestions, Mr. Cutler, in terms of crediting Mr. Serra for amounts that Ms. Serra may or may not owe to him. The problem with that is, how does that get overseen? And how does anybody really know how much Mr. Serra is withholding and whether he's actually putting those amounts towards the student loans or not? And I am not going to hold a hearing every month and hold the hands of both these individuals every month and make determinations on a monthly basis about who's paying what and how it's being paid. So I'm going to make this really, really simple as we go forward here. And although, again, I don't think it's the court's obligation to come up with a solution, I'm going to provide the parties with an avenue for a solution before the court issues any kind of sanctions or coercive contempt actions. I'm going to give the parties 60 days to go to mediation. I'm going to refer this to the mediator, the community mediation, in my referral to community mediation, I'm gonna outline the issues and ask the mediator to specifically address with the parties solutions so that the two of you can proceed on a monthly basis and carry out both of your obligations. And what it's really gonna come down to, because ultimately the two of you, Mr. and Miss Sarah, the two of you are gonna have to have some communications. The two of you are going to have to discuss how this can go forward, because ultimately any long-lasting solution to this problem is going to have to come from the two of you and not from the court. And that's why I think mediation is appropriate as a way to potentially go forward. I'm going to ask the mediator to provide the court with a written report following that mediation as to whether or not it was successful and to what degree. Typically, I just get a short report from the mediation service indicating whether an agreement was reached or not, but in this case, I'm going to ask for a little more detail from the mediator. And then to the extent that there isn't an agreement after that 30-day period, the court is going to set this for a show cause hearing. It'll be in person here in court. If either party has failed to comply with their own obligation under the judgment or the court's opinion, or has failed to reach an agreement as to how to meet that obligation through the mediation process.
This is the last chance. The judge explains what contempt sanctions look like: financial penalties, coercive orders, or jail. The warning is psychological as much as legal. By mentioning jail, the court raises the pressure. It tells both sides the fight has real-world consequences beyond paperwork. If they keep ignoring the judgment, the next hearing could decide not just money, but freedom. That's the reality of court enforcement.
Then at that point, the court will determine whether there is a violation of the court's order, whether there is a legally recognizable excuse for that violation, and if there's not, then the court will issue coercive sanctions. The last thing that I ever want to do in a civil case is impose some type of jail sanction to coerce a party to comply with the court's judgment. However, I think at that point, we will have exhausted all available remedies, and both parties should be prepared to the extent that they have not complied with the court's judgment, provided a legally recognizable excuse for not having complied, then the court will issue contempt sanctions, coercive contempt sanctions, which could include fines, other coercive orders of the court, or including up to incarceration until the non-compliant party comes into compliance. I want to make sure that everybody is clear that again, this is not going to turn into a monthly finger-pointing session about who's not doing what they should be doing. Both of you are adults, both capable of handling your own affairs. You both need to come up with solutions for how each of you are going to comply with your own obligations. I'm going to provide, again, an avenue through the mediation service to facilitate some communication between the two of you as to how to make that happen. And if it doesn't, then I'm left with no other option than to coerce you through the powers that I have. And I just want everybody to be clear that I will not hesitate to use those if that's the court's last option. So I will issue that order today, referring the matter to community mediation. When they reach out to counsel and the parties, everyone needs to cooperate with that process. Once I've received a report from the mediation service, then the court will set this for another hearing as necessary, and those orders will go out today. That's all I have. I need to move on to my 2 o'clock hearing. All parties are free to disconnect at this time.
May I, Your Honor, may I say one more thing?
Nope, I need to move on to my 2 o'clock hearing. I'm sorry. Thank you.
Have a good day, Your Honor.
The hearing ends with no full resolution. The disputes are now heading to mediation. Mediation is a final chance for both parties to cooperate and find solutions outside strict court control. If they fail, the judge has made it clear: enforcement Powers will come next. That means no more patience, only penalties. This case shows how divorce battles spiral when neither side works together. For more breakdowns like this, remember to like, comment, and subscribe.